Hello, welcome to the Guardianship section of the ULV Justice Center website. We're glad to walk you through the guardianship process. Let us tell you about the general guardianship process. We'll then walk you through the process of filing a request for guardianship with the court. And we'll talk about the burdens of proof you will need to deal with in order to become a guardian. Disclaimer: the information provided here is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. The page below will provide you with the specific forms you will need to begin this process. The forms are indicated by words that are the color blue. Pressing the blue word will take you to the specific form, which you will be able to complete online. The first step is to complete the necessary forms. Make copies of the forms you complete. The court will usually require 1 and sometimes 2 copies, and you will want to have a copy, so it is advisable to make at least 3 copies of the forms you complete. You will then file the forms with the court. Usually, you'll file the forms in the county where the child lives, but if the child custody case has already occurred, say from divorce, and that took place in a county other than where the child lives, you must file guardianship papers in the county where the child custody orders exist. The reason for this is so that there will not be 2 different courts issuing custody orders about the child that could conflict with each other. If people who have a right to voice their opinions in court agree that you should be child's guardian, they can complete the waiver of notice part of the consent to appointment of guardian, and they will not have to be notified about the hearing. You may be asking, who has a right to voice their opinion in court? Well, the child. If the child is 12 years of age or older, both of the child's parents or the person with current legal custody, the child's grandparents on both sides, meaning the child's mother's parents and the child's father's parents, as well as the child's brothers and sisters and half-brothers and sisters. The next step is to give notice. The law requires that notice about the guardianship hearing must be given to the people we have just discussed. There are specific rules about who must be personally served and who may be served by mail, and these rules must be precisely followed. The court provides proof of service information instructions in both English and Spanish, which you will find under Section 5 of the page below. As we mentioned, some of the child's relatives must be personally served, and some may be served by mail. The person who serves the notice, either personally or by mail, cannot be a party in the case, meaning that it cannot be the person seeking guardianship. The person serving notice must be someone who is 18 years of age or older. The county's human services and social services must be served by mail, and if not related to the child by blood, marriage, or adoption, the State Department of Social Services must be served by mail. The person performing the personal service and service by mail must provide you with proof that services have been completed. But what happens if you cannot find someone who must be served? California Rules of Court 7.52 allow that if you file a declaration with the court that you have conducted a diligent search and you request the court to grant order dispensing notice, the court may either waive notice or prescribe a different manner to give notice to the missing individual. Your declaration should include the last known address, the internet search you conducted, a search of property indexes, telephone directories, inquire of relatives, friends, employers, and family members. If the judge agrees that you have exhausted every way to find the missing person, the judge will sign an order dispensing notice form, waiving notice to that missing relative, and your case can move forward. California law requires that unless the judge waives it, an investigation must be conducted in all guardianship cases. The judge will rely on the investigation report to make a decision. If proposed guardian is a relative, the court will appoint an investigator. If proposed guardian is not a relative, then the case will be referred to the county's Human Services and Social Services Department, and one of those organizations will conduct the investigation. The investigation report that is generated is allowed by Probate Code Section 1513 D. To be reviewed by you, it is a good idea to obtain a copy of the report before the hearing so that you can address any issues that the investigator may have before you go to court. You may be wondering what the investigator will want to know. Some of the more important things will be how long you anticipate the guardianship will last. The investigator will want information about you, such as your social history, a verification of your employment, and the investigator will want to provide character references. There will also be an investigation to the child's social history, as well as the child's educational records if the child is of school age. The whole process will cost money. The total outlay will be about $1,300. But if you cannot afford the process and you qualify, you can file forms with the court to relieve you of having to pay these costs. You will find information below which details the qualifications for fee waiver. After completing all these steps, you are ready for court. But what should you bring to the court hearing? Well, if the court orders it, you must bring the child, an order appointing guardian, letters of guardianship, all other court papers, copies of your proof of service form showing that notices were properly served. Let us tell you about the legal standards that must be met to obtain legal guardianship, and how the judge decides who should be the guardian of the child. Now, I know this looks a bit overwhelming, but I am going to walk you through this so that it will make sense to you. If one or both of the parents objects to the guardianship, a judge must consider the following. First, is the child currently living with you? The person seeking guardianship? That would be the de facto parent in our slide. And while living with the child, have you, the de facto parent, provided the day-to-day role of the child's parent, fulfilling both the child's physical needs and the child's psychological needs for care and affection? And has this living relationship existed for a substantial amount of time? If the answer is yes to all three questions, and it can be proven to a judge by preponderance of the evidence, the burden to convince the judge moves to the parent who is objecting. In this slide, you see POE, meaning a preponderance of the evidence, which means that you must prove to the judge there is a greater than 50% chance that it is true. So if you prove to the judge that it is true, then the parent must show by preponderance of the evidence that parental custody would not be detrimental or harmful to the child, and guardianship is not in the child's best interest. If the parent cannot prove that to the judge, then the court will grant your guardianship petition. If the parent can prove that to the judge, then the court will deny your guardianship petition. But if you're not currently living with the child, the court must be convinced by clear and convincing evidence that the guardianship is appropriate. Clear and convincing evidence is a higher standard of proof than a preponderance of the evidence. Clear and convincing evidence means that the judge must be convinced with no serious doubt. If the judge is persuaded, the judge will then consider if placement with you is in the best interest of the child. If the answer is yes, the court will grant the petition. If the court is not convinced by clear and convincing evidence that parental custody would be detrimental or unfavorable, then the parent will keep custody of the child. This has been an overview of the process to obtain guardianship. As I mentioned in the beginning, the information we have provided here is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney. On behalf of the LV Justice Center, we thank you for your time and hope this information is helpful in your legal matter.